Hey everybody, good morning. I'm JD Houvener, CEO and founder here at Bold Patents Law Firm, and welcome to our 9 a.m. noon Eastern Bold Today show. And I've got a special guest. You may be able to see him off to the left or the right, and he's going to be introducing himself. He's a client of ours. I'm very proud to have him on. Just got his patent granted, so stay tuned for more on that. Our regular show, I'm going to be happy to answer any live questions that you guys have got about patent law. And as always, I offer a disclaimer. Please do not make this a place to share your invention. That is a confidential piece of information, so please do hold that for any future consults that you may have. This session is really just for the inventor, right? And there's no dumb questions, right? Anything goes in terms of what you may be on your mind with respect to how to get started with a startup idea. Maybe you're midway through, you filed your own invention, you're stuck, you need some help from a high level. That's what this is all about. And I did provide a link here. We're going live on 3 different platforms for the first time, so I'm kind of excited to see what the results are on Facebook, on Google, and also on Twitter, their Periscope app. So we could be getting comments from all 3, and just know there is sometimes a lag. So if you've asked a question and I'm not getting to it right away, wait a minute or even 2, and I'll try to get to that, okay? And I will prioritize live questions over those that I'll be going to on the AVO dashboard. Good to see everybody. We have 2 viewers already, so I'm happy to see that. And if you're enjoying this information, you want to see more people on here, just give us a like and share this information with your own personal social media, your own friends group. I'd love for this to be a vibrant, thriving weekly meeting where inventors can come together and ask process level questions, legal questions about how the law is changing, and also celebrate with me and with our clients with some of these successes we're getting. And nothing better than hearing it, not from me, but from an inventor. So that's why I brought on Jack Armstrong here. He's the president and CEO of QR Pet Store. And so we'll be looking at talking about his one patent he just got so far on a design patent for an animal collar. So Jack, I'll bring you on and let you introduce yourself, and we'll take it from there.
Good morning, Jack Armstrong, president of QR World Inc. I've been working with JD and his crew on a design patent for an animal collar. This is the collar itself. It's called the shark fin collar. And of course, its face shaped like a dorsal fin. So that's where the name came from. It allows a lot of area for design. And this is a laser design that was engraved and then hand painted. So unlike most collars where you can just put the name Fido across it, in a linear pattern, this allows for a lot of design options.
Right. A lot more area, a whole lot more area than and visible from a distance, perhaps even, right?
Correct. And dogs with heavier coats, a lot of times the collar just gets lost in that coat, but the shark fin collar can stand out and, shows off better. And of course, it's very unique, so it gets a lot of comments. People are really curious about the collar.
Right. Well, and before we went live, you introduced me to Tucker. I don't know if he's still around, but he's wearing one of your shark fin collars.
Come here, boy. Come here, boy. Come here. Tucker's our research and development team. Come on. Come on. Come on. Come on.
Oh, look at that.
Tucker is the perfect R&D dog because he's tough. He loves to play tough and, roughhousing with other dogs. And that's the problem with a lot of collars on the market. They can't take that kind of abuse, if you will. So the shark fin is made with super high quality leather, US made. It can handle, the scrapes and bites and all the things that a active dog will give it. And it's super tough. It can take a pit bull or whatever kind of dog you put, whatever one you put on it, it's gonna last.
Right. Excellent. Well, so for those of you who don't necessarily know what I mean, they've never even seen a patent or don't know what that means. What I've got is your actual patent pulled up here. If I could share a screen just to kind of go to that. For some of those that may not even have ever seen a patent document, then we can go through kind of what you own, right, as the patent owner. So let me share a screen here. And there it is, right? So this is the cover sheet of a patent. You can see what the patent number is in the upper right, and you can tell right away this is a design patent. And so it's got the big letter D here, and then your number 891708. And so there's actually fewer than 1 million design patents that have been issued to date. That's your number, and obviously just got issued. And for design patents, you get 15 years from the date of patenting. So you've got until 2035 to go dominate the market. No one else has the ability to make, use, or sell this invention. Just a few of the things to highlight here. The whole process of acquiring the patent isn't just like, hey, just submit the information and you get your patent. There's a examiner that will take a look at your invention and make sure that it's new. And so you can see what happens here in this paragraph 56. All these different designs and even utility patents that have been issued or filed before, the examiner said, well, these are pretty close. And so you've got to convince me that yours is unique and differentiated from even these other references. And of course, we were able to do that. Want to give definitely some credit to your attorney, Chris Melee, who you worked with to get the patent granted.
Yes, I have to say, JD, I was holding my breath because there was some similar designs, and it was, open to scrutinization by the patent office. But Chris handled it extremely well, knew how to couch the description and what we had, and that's what finally pushed it through.
Well, thank you for sharing that. I've always been impressed with Chris and his ability to just remain calm amid the storm. I mean, he is our go-to. He's who I would want in a patent attorney. I do want to point out too, an actual drawing. Okay, so in a design patent, here, let me actually scroll, let me zoom back out. This is the key characteristic of a design patent, is the claim, okay? And so some of you that may be attuned to patent claim language, you're familiar to a huge long list of numbered paragraphs. Well, that's for utility patents, right? So for design patents, you just get one. And so it's plainly identified as the ornamental design for an animal collar, as shown and described. And it's described here in the figures. This is really all you get in terms of the description. You really want that design, the drawing, to control, because that's actually going to keep your rights as broad as possible. So we have just 3 figures. And one of the cool things about designs that you can play with is solid and dashed lines. And so in this case, you can see the outer, the perimeter of the collar is in solid. And it's kind of actually a little bit of a rough portrayal, but this is a solid line here. And what's in dashed lines, you can see is this buckle. You see how this is actually in dashed lines? The oval buckle and the swivel and even these, but they call it like a brad attachment, whatever that is, to actually go through that collar is dashed, meaning it's unclaimed. Unclaimed. The benefit there is that the buckle can take any shape, right? And it's going to allow you as the inventor, as the business owner, to design whatever feature or element you want to secure the collar, whether it be Velcro or some of the more robust steel, or a big belt buckle. And same, they give as many or as few holes as you want, because it's all in dashed lines. What really you're able to capture is the shape, the true shape of this, with the definitive, distinctive shark fin ornamentation. And so, yeah, that's a cool aspect about design patents. Again, you can see the solid line covering the shape of just the outer periphery of the belt on that design. And also you have the side profile as well. Okay, excellent. Well, I don't see any live questions here as of yet. So we'll we'll just kind of move on. One other thing I do want to share as well, if you don't mind, Jack, I'll just show off your website a little bit, give you a bit of free press, you know.
Sure.
So let me do that. Let me share a screen. I've got your website, which is, and I shared that in the comments too. It's qrpetstore.com. And I think you were sharing before the show, it's a family business. You're working with, at least for now, and growing, but you're advertising and have been selling products for a while. Is that right?
Yes, for 2 years. We okay. Carry other manufacturers, only U.S. made products, to give the store more product line. I mean, it amounts to having more critical mass as you start. As we grow, we probably will just specialize in our own products, but at this point, we're selling other products as well.
Right. Excellent. Well, good deal. Well, Jack, again, thank you for coming on the show. It's my pleasure being clients on, especially celebrate with them. I think, one of the cool things about having clients on is being able to share their story, a little bit about working with the attorney at the firm, and also get some more news and information on about what your product is and how to move forward. Because a lot of inventors that come to us for the first time, they're like, gosh, how am I ever gonna, move this into, is this patentable? What does it look like on the end? And so being able to showcase someone that's gotten to, one of the finishes lines, getting to the point to where you can say this is truly yours is important. But then beyond that is how you're going to bring it to market and have good success. So please keep us up to date on your journey as you move forward, and we'll hopefully have you back, perhaps, who knows, a year or two from now after you've had more success.
Appreciate it, and thanks for having me on today, JD.
You bet. Take care, Jack.
Okay. All
right. Well, that's cool. That's good stuff. So let me do this. I'm going to jump to our regular Q&A from avlo.com. And so I've got 2 trademark application questions and 1 patent app question. So I'll jump to the trademark ones first. And yeah, if you're listening live, feel free to jump in with comments. I don't see any yet. Like I said, I will prioritize those if they do come in. So this first one is, let's see here, trademark application question. This is, can I copyright a neologism? Neologism? I don't know. I'd like to register a neologism as a domain name. I don't even know what a neologism is, so I'm actually going to Google that right now. Let's see what in the world that is. A newly coined word or expression. Oh, okay. Okay. Let me get the neologism. Okay, I just heard from Google how to pronounce it. Neologism. Recently, is a relatively recent or isolated term, word, or phrase that may be in the process of entering common use, but has not been fully accepted in the mainstream language. Okay. Well, so this is, the question is, can I copyright it? But what you meant is, can I seek trademark registration on a new type of word or phrase? Sure, absolutely. If you can show that you're using that term for your specific industry. And if you've been using that in the stream of business, interstate, meaning selling out of state. So, a few requirements to meet there. Obviously, you can't use a term that is being used by another company or brand for the same classification. So let's say, I don't know, what's an interesting word, blasto. Let's say blasto is a term that's coming into definition, and it's a neologism. And blasto is sort of the new, you're making a new line of speakers, and blasto is the name of your speaker. You would need to take time to make sure you either do it yourself or hire a law firm or to do a trademark registrability to make sure that there's clearance. 1, to make sure that there's no one else using the mark, and then 2, to see if there's anyone else that may be already having rights on that you may be infringing if you decide to use blasto as your new name. And then eventually, of course, file the registration. So hope that helps you answer that question, and also differentiate between copyright and trademark. So this definitely was a trademark question even though you were looking for copyrights. Let's check back in. Looks like we have a good question here from Yugoslav. Thanks for your question. Can we negotiate licenses with a company with a PPA? The answer is yes. Yes. So a PPA is a provisional patent application, and these are the less formal version of a patent application for a utility invention. And yes, you can. Okay, as soon as you become patent pending, that means you've gotten the entire invention, hopefully, if you've done it right, filed in your written description and any drawings, but you just haven't yet filed a full formal non-provisional yet. You can definitely start conversations. And I actually recommend inventors do a whole host of things as soon as the provisional is filed, including seeking investment capital if you need to the next big investment chunk to go start on development, or taking it to trade shows, making several or hundreds to get customer feedback, so that you have at least some forward momentum that you believe, hey, look, this is doing well in the market. I'm getting some market share, or there's real good potential. And then even better than that is you get all the improvements, all the iterations can get put into your non-provisional once you decide to lock in claim language. Your specific question about talking to companies that may want to license your invention, absolutely. Just know that you're not going to be able to get as good of a deal potentially if you're licensing a pending application. The company that will be accepting the license, the licensee, is going to be taking the risk that the invention is patentable, right? The examiner likely will not even review a provisional. They won't see it until it gets filed as a non-provisional. So they're likely going to have to hire their own patent attorneys to take a look at your application, to see if they've, to see sort of the merits of it, to see really how novel is this, before they were to, for sure, lock in a contract with you. So it's more tenuous. You'll likely get a worse deal, if you will, when you license a pending app versus a issued patent. Okay, hope it helps answer your question. So let's take a look at the next one from Trademarks. So this is coming out of Los Angeles, California. So after you receive a non-final office action, are you allowed to change your trademark? I just want to know more if this option is better than restarting a trademark from scratch. So non-final office action, this is pretty standard for trademarks. So there's just like for patents, if you receive a non-final, that just means that, well, the examiner found something wrong, substantive with your application, and it needs to be responded to, whether it be a legal argument or they found maybe a prior art or another group or entity or brand that's already using a similar mark. You just need to maybe tweak or make amendments. That happens all the time. And so I wouldn't give up. It's going to depend, of course, on your case, on how on point or how difficult the office action is to respond to. To carry through my weird example from before, Blasto for speakers. Let's say that there was already a company, that had Blisto, Blisto speakers, and if Blisto, had their trademark registered 2 years ago, and you just started Blasto and you've only been selling for a couple months, the trademark examiner might say, gosh, it sounds so much like Blisto, and you're in the same exact area of business. We're going to reject it. Okay, and so you may need to come back with, well, no, Blisto and Blasto are different, and here's why, and here's some case law showing how even a modification of one letter can significantly change the perspective of a customer, right? And so you have to come. That's legal argument, or you come back with a change to Blasto O. Maybe you end up wanting to do an extra O at the end, and it's Blasto is your new trademark. That can definitely happen during what's called prosecution while you're responding to that office action. You don't need to start over from scratch. Okay, so let's take a look at our screen to see if any other questions came in. I don't see them just yet. So we'll move on to the next one here. I've got just one question on the patent side this week. And I'll just share a screen really quickly just so you can see this. This is what I actually look at every week for those of you that have been following along. AVO dashboard. So I'm a volunteer patent attorney on avvo.com. This is my profile, and you can see Q&As that I've given over the years. I've answered 181 questions. So I do this every week. I'm subscribed to these various questions, and so this week I've gone through those 2 trademark questions and gone through 1 patent question today. So I'll leave it screen share mode. This is coming from McDonough, Georgia. Of course, they leave the individual's name anonymous. I created a stuffed interactive teddy bear with a soundbox audio recording. How do I protect from someone making a similar bear? What are the attorney costs to protect my invention? Well, cool. I think it's a great idea. I just want to make sure we don't talk about specific inventions here. And so this would, of course, be very specific to what this invention is about. I think we'd want to be careful to identify how the sound box is integrated with the bear. Maybe there's a specific way in which the wiring is done, the way the sound is, how it interacts. If there are any type of tangible, tactile interactions, whether you squeeze the hand or you touch the nose, or maybe it's actual audible signal that sort of the other sound box responds to. Whatever it is that signals that audio box to play, and whatever integrations there may be with that actual teddy bear will be very important. And so we'll hone in on those areas of potential novelty and then move forward with the patentability search, right? We don't want to just blindly file a patent application before looking to see what else is out there on the market, what else has been published before, so that we know truly whether this invention is new. If we're able to confirm that some aspects of this are new, then we'll recommend filing an application. And once you get an application filed, we all hope and cross our fingers that things will get through. The examiner won't find anything we didn't, and it'll be issued a patent. And from that point forward, you will then be able to say that, yeah, you're the only one that's going to be able to make, use, and sell that teddy bear with this specific type of sound box. So give us a call at boldip.com or shoot me an email if you have further questions on that. All right, so let me just stop sharing here before we go into warp zone. I just had that one question from Yugoslav. So any other final questions, shoot them right now. We'll look to kind of wind down the broadcast. For those of you that may be new or don't actually have a copy yet, I am giving away this book. I wrote a couple of years back, Bold Ideas, The Inventor's Guide to Patents. This is available on our website. I'm going to put up on the link, you should see that above, to grab a copy of that on our website, boldip.com. And this is a nice guide. This is sort of my 5 or 6 years doing this. I plugged all the main top questions and answers to those in this book. So it's a great tool for you to be able to get started. What's the difference between a patent and a trademark? How long do patents take? What do they cost? And of course, as some of you know, I've got a blog article as well that I keep pretty well up to date and spend a lot of time personally writing. So check out our website for more details there. Okay, well, I don't see any. Oh, let's say one final question from Yugoslav. Can you tell us what the percentage is with the PPA from, okay, with the percentages? Well, not sure what you mean. Well, I gave you a couple. So the percentage of provisional patent applications that get converted into a non-provisional, maybe 75 to 80%. I think most inventors that file a provisional do end up moving forward and getting the full non-provisional filed. What percentage of those turn into patents? Maybe, again, maybe another 75% will actually get issued. Some of them do get stuck, right? So that other 25% that don't move forward with the non-provisional, maybe they tested the market, maybe some capital didn't come through, other business prospects came up and they just abandoned their provisional. And then, of course, some patent applications just don't prosecute. I mean, an examiner finds something spot on, or there's a problem during prosecution, or the business folds while the patent is pending, and then it goes abandoned. So there's a lot of different reasons why an invention might get stuck in that patent pending phase. Okay, it looks like you maybe been asking about a percentage royalty for a provisional. That's going to vary. Every case is different, depending on what kinds of products. Okay, if you've got a a hardware, an apparatus, device type patent versus a method, a software system. Each market is different. Each market is different in terms of what they'll pay out on royalties. I'll just give some answers because I like to use actual examples. So for toys and games, hardware toys, think like Teletubbies, right? If you're familiar with those, those are generally going to be on the lower end. Okay, 3 to 4%, sometimes 5% royalty, meaning you sell them for $1, 3 to 4 cents of that sale will come back to the inventor. Okay, just to use round whole numbers. And that's for a granted patent. All right. And so if you were negotiating in the patent pending phase, I would say in the neighborhood of a half of that. So maybe 2 to 3% would be all you could expect, because there is that added risk of the patent may not even get through. The company taking the license will have to do all that work in terms of enforcing it against any infringers. I can't speak specifically to the solar industry. Our main focus at our firm is to do patent prosecution, which is the acquisition of the patent, doing the research and getting rock solid patents. We actually don't do any of the brokering and the selling and the licensing at our firm. I just know of these stories from some of our clients that have worked through that. But thank you for your question, Yugoslav, and I appreciate that. All right, everybody, well, have a good rest of your day, and we'll see you next week. Go big, go bold.